What's up, guys? Welcome back to another live stream. Today, I start with scripture regarding the Young Thug case, judged removed in Fulton County drama explained. We're going to explain this all the way through. What the Bible says about this, I believe, interpreting the Bible for this situation, is Luke chapter 12, verses 2 to 3, and it reads, "The time is coming when everything is covered up will be revealed, and all that is secret will be made known to all. Whatever you have said in the dark will be heard in the light, and what you have whispered behind closed doors will be shouted from the housetops for all to hear." And without further ado, let's get started. Okay, guys, we're gonna look at the shocking truth behind why the Young Thug case judge was removed. You won't believe what really happened in Fulton County. And without further ado, let's get started. Guys, in this live stream, we'll dive into the latest development in the Young Thugs YSL case in Fulton County, where Judge Ural Glanville was removed. And the Fulton County Judge Rachel Krause recently ruling on the recusal motion filed by defense attorney sheds light on the drama unfolding in the courtroom. Find out why the motion was granted from Deamonte Kendricks and Jeffery Williams, leading to Judge Glanville's removal from the case. Stay tuned as we explain the reasonings behind this decision and the impact it has on the ongoing legal proceedings at hand. And without further ado, let's start. All right, let's jump into it. Have you ever wondered why the judge was removed from Young Thug's case? Well, I want you to stick around because today we're going to dive deep into the Fulton County drama that has everyone talking. First off, let's set the stage with a quick intro. We're going to explore the controversial decision to remove the judge from Young Thug's case in Fulton County. This legal saga has definitely caught the attention of many. So let's break it down. Now, before we get into the nitty-gritty details, let's provide some context behind this. Young Thug is a prominent figure in the music industry, found himself embroiled in a legal battle that has major implications, and Fulton County, known as a significant in legal matters, plays a critical role in this case. Next, let's highlight the key events that led to the judge's removal. From legal maneuvers to the courtroom drama, there's a lot to unpack here. So I'm gonna do that right now. This is where things start to get interesting. Let's take a look at the courtroom that started this train that led to the judge recusal. Also now, let's dive in deeper into the reason behind the judge removal. What controversy surrounds this decision, and how it might impact Young Thug's case moving forward. It's time to analyze the situation from all angles. So let's get ready. Let's read the court order. But before we read the court order, it is a must that we must look at the video that brought about this recusal. So let's open it up. Sorry guys, it's raining outside, so my dog is going crazy because
Morning,
the wind
please,
is
sir.
blowing. Let me just stop this real quick. Excuse me.
You all right?
Bear with me. Let me just set it up real quick, and then we'll get started. So we're gonna be looking at the full. We're gonna be looking at the full video of when this recusal took place. Okay. And then we're gonna look at the court document that also took place. So let's do this. Oh, you know what? Let me do this. Let me put my earbud in. So I can monitor it in my ear and won't get feedback. Again, sorry for my dog. The wind is blowing, so that's why she's acting crazy like that. Okay, guys, so let's get to this. So we're going to look at the video that led to the recusal.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot. You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk.
well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then, other than
Answer
if
that
you were
on the
if you were sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton. Or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I
for
understand that
mistrial.
you spoke with a
And when-
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day. So-
court. I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when
It's okay, Marissa.
somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it
The
supposedly.
state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because
what
unless
I
you're
got-
sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
I'll
entitled to the-
that's
But isn't that the issue?
that leads to be told. But,
But,
State, do you have
right
anything you
now,
want?
we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section
because
1, paragraph
you've
12.
already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love.
Excuse me.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms. Law.
okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser. Okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey? Okay, all right. Okay, Mr.
And I'm adopting all of the statements.
All right,
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Williams Huey.
okay,
We are also adopting all the arguments that have been made by
All right, sir.
Attorney Steele, by Attorney Pete Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on, even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for a mistrial. I believe it is appropriate here under these facts and circumstances. Thank you.
all right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Gardner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
Okay, guys. So we now know what took place within that courtroom. So now let's read the judge's order in regards to recusing Judge Glanville from the case. So let's talk. Let's look at the court document, and let's review that and see exactly what what transpired. So as you can see, and let's go line by line and let's look at it. So it was important for us to look at that video to get a better understanding of what took place. So I'm not an attorney. I'm just reading what the court order says. So let's get started. So obviously we see that it's in the Superior Court of Fulton County, the state of Georgia. And we do see all those attorneys that stood up in regards to the defense of their clients. Deamonte Kendricks, Jeffrey Williams, Khalif Adams, Rodalis Ryan, Shannon Stillwell, Quamar- Quamarvius Nichols, and Marquavius Hughes. Okay, so let's begin to read. And we're also going to read the notes at the bottom to get a better understanding. So you'll see that it's in context in regards to everything else, right? Okay, let me move this over to the side a little bit. Okay, and it reads, this case is before the court considered various motions to recuse, including the defendant Deamonte Kendrick's motion to recuse Chief Judge Ural Glanville, filed on June 12th, 2024, Kendrick's documents 247. Also, we see Kayla Bumpus motion to quash the show cause order and or to recuse Judge Granville on Adams docket Okay, sorry guys. The storm outside is going crazy. You hear my dogs going crazy. So thank you very much for sticking around. I am still here. Let's get back to this court document. As long as you can hear me. If you can't hear me, let me know. I know this storm is pretty bad, just like someone in the live stream said. Okay, let's continue. So we see where we left off was Kayla Bumpus' motion to squash the show cause order and or to recuse Judge Granville, Adams document 171, and the defendant Jeffrey Williams' motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case and amended the supplement. It also goes on and it says the specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follow. The note that is noted here is this court previously considered and denied defendant Kendrick's motion to disqualify Fulton County Superior Court judge from ruling on recusal motion Kendrick document 260 and the portion of the defendant Williams amended supplement that sought this court's recusal in Williams document 612. It goes on from that note and it says this. These recusal motions arise out of the multi-defendant prosecution brought by the Fulton County District Attorney's Office, alleged gang activity and associated crimes, Kendrick Document 4. Although there was 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motion to recuse all arise from the same circumstances related to the state witness, Kenneth Copeland. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effects of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated that he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury, and Khalif Adams, for this note on page 2, Khalif Adams' case was severed, and though he is not currently on trial, his case was transferred to this court because Kayla Bumpus' motion to recuse Judge Glanville in association with the show cause and contempt issue was filed in Mr. Adams' portion of the document. And this is in Adams document 171. See certified transcript in June 7, 2024, and Williams document 605. The court order goes on and says, then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th at 2024 at 8:30 a.m. and court was adjourned for the day. On June 10th at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not appreciate in the meeting, did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Mrs. Love told Judge Glanville that she wanted to meet to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Miss Love also expressed concern to Judge Glanville about Mr. Copeland's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effects of the state grant of immunity to Mr. Copeland. It goes on and says that Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Miss Bumpus, Judge Glanville, and Simone Hilton. This is the note at the bottom of the screen, as you can see. 2 investigators from the DA's office and multiple deputies were also present, as well as 1 and more members of Judge Glanville's staff, including his court reporter, who took down the conference. The certified transcript was filed in the record on July 1st, 2024, in Williams document 598. It continues. Counsel for the state, who had joined the meeting during that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trial of all defendants in the case. Not just 6 currently on trial, Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibility after grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Miss Bumpus, and then advised the court that he would testify. After the meeting, immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chamber meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chamber meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams, ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. Kendrick's document, chapter 245. An amended show cause order was later entered setting July 1st in 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed by Deamonte Kendricks on June 12, 2024, Kendrick's document 247. And Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper, coercive ex parte meeting with the state. On June 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review, contains assertions of facts to support the allegation of bias and partiality. Adams document 247, page 7. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chamber meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. It goes on and says this. On June 14, 2024, Kayla Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17th, Jeffery Williams filed his motion to recuse Judge Glanville, Williams document 587. Divorced from its hyperbole, Mr. Williams' motion and supplement also seeks to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleged was improper and coercive. Mr. Williams' motion. The footnote for page 5 says this. Technically, Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt action during June 10th proceeding. However, that motion was made orally, and it is not before the court because Mr. Steele's contempt matter is currently pending before the Supreme Court in Williams document 614. Although referred to this court for consideration, Bumpus' motion to recuse is both premature and moot because Mrs. Bumpus has not yet held in contempt, and because on July 1st, Judge Glanville canceled the show cause hearing. It goes on and says, alleges both actual basis and the appearance of bias because Judge Glanville allegedly participated in accusatory process when he met with Mr. Copeland and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer Brian Steele in contempt. On July 1st, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of the making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also expressed how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he has not instigated an investigation into surveillance footage, but had reviewed such footage for a timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant laws that supported his inherent authority to hold such a meeting. Judge Glanville maintained no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendant's right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motion filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motion to recuse were assigned to this court for consideration. Now she lays her legal framework. She says this: motion to recuse are governed by a specific legal frame outlined in Rule 25 of the Uniform Rule of Superior Court. A party seeking recusal must file a timely motion supported by the affidavit clearly stated the facts and reason for the belief that bias or prejudice exists. So what they did was they sent it, they filed it, they sent it over for her to be able to determine was there bias or was there prejudice that exists. She goes on and she says the affidavit must be definite and specific and described. So this is what it says: the circumstances of extrajudicial conduct or statement which demonstrate either bias in favor of any adverse party or prejudice towards the moving party in particular, or the systematic pattern of prejudicial conduct towards persons similar situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. So it's giving us a definition of what the specific definition of it is. She says, bare conclusion and opinion not legally sufficient to support the motion or warrant further proceedings. Once such motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeline and legal sufficiency of the affidavit alleged facts. If all three criteria are met, the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal. Another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, assigned judge should be guided by Rule 2.11 of Revised Code of Judicial Conduct, which provides that judge shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than affected judge or other interested parties. If a motion to recuse satisfies three threshold criteria, this is the three threshold criteria of how a judge is recused. The assigned judge must refer the motion for reassignment and may not oppose the motion. They give case law, Mundy versus Magnolia Advanced Material Inc. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically. No matter how false or even defamatory the judge might know or perceive the allegations to be, a judge cannot become actively involved in the presenting evidence or argument against a motion seeking his recusal without the defense itself becoming a bias for a recusal. She gives a statement. She shows what that looks like, what the law states. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His effort at defending himself against a motion to recuse will inevitably create an appearance of impartiality or appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create empathy, which persists after the motion to recuse is denied. So they gave us at the bottom, the footnotes, it says this. Excuse me. Richard E. Flame, judicial disqualification, recusal and disqualification of judge. A judge who personally refutes a party allegation of judicial bias may appear to be reasonable person to have exhibited personal interest in the outcome of the litigation, or to have aligned himself with. So what they're saying is that, So now her analysis and her discussion says this. She says, here Judge Glanville had previously announced on the record that the motion were timely and supported by affidavit. And transferring the case to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for assignment and was prohibited from opposing the motion. So this is what this is where she's saying he went wrong. He wasn't supposed to oppose the motion. It goes on and says, worth noting that this court agrees generally with Judge Glanville assessment of the property of the ex parte meeting. While the meeting could have had perhaps should have taken place in open court, nothing about the facts of the meeting and the substance discussed was inherently improper. However, in his order denying Kendrick's motion and in his process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegation, and otherwise explained his discussion and action and argued why those actions were proper. So this is where he went wrong. This is where the judge went. I guess this is what she's saying, that the judge went wrong. While it may be improper for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is an objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as the recusal issues, and in rule in Kendrick's motion, Judge Glanville, it says in the notes, it says this: party resisting the judge's disqualification and by attempting to refute a charge of bias, a judge may become or appear to have become an adversary of the party seeking his disqualification. It goes on, it says, evaluated and accepted the truth of his own factual allegation, mandating his recusal. The court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motion were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling this case. So now we start this. Now she says, because of the necessity of preserving the public. So pretty much saying, in the public eye, the people will perceive this. The public's perception will be altered if he continued to preside over this case. She says weighs in favor of excusing Judge Glanville from further handling of this case. So she recused him. So we see, based on the foregoing, the court hereby orders as follow: the defendant Deamonte Kendrick's motion to recuse Chief Glanville is granted. Kayla Bumpus' motion to quash and show cause order and or the recused Judge Glanville is denied as moot. So she's saying, when they say moot, that means nothing ever came of it. So it was moot. It was just filed. And it says, defendant of Jeffery Williams' motion to disqualify recused Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. And it was filed by the clerk. So that's what we have here. That's what took place. So what do you guys have to say about it? What's your thoughts? What's your thoughts about it? I want to know how it might. What I really want to know is how it might impact. I'm going to do some studying, and I'm going to do some research and see how it might impact the case going forward. What happens now? I'm not an attorney, but we just read the recusal and how Judge Glanville was recused from this case. So I really want to find out what happens next. What transpires next after we done seen this document? We have looked at it, and that he's been knocked off the case. What really happens? On more on a personal note, do you guys have any insight or connection to share regarding this? I want to know. Do you guys have anything that you want to say about this? What do you think about it? Because the legal system in general, feel free to chime in and let me know what's your experience or what you think about what's really happening here, because now he's off the case. I remember hearing that their attorneys were saying that if he is recused from the case, there's no way for them to rewind back before the violation took place. So what really may happen is that this case might be actually there might be I'm sure they're going to have a motion to for a mistrial. So they did the motion to recuse, but now the motion for mistrial might happen. So we have to look at that. We have to take a really good look at that. So I'm interested in that. So let me know what you think about in the comments. What's your opinions and stuff like that. As we wrap this thing up, it's time for the verdict. What are your implications of the judge's removal of Young Thug? And on a scale of significance, how would you rate this drama? Let me know in the comment section below. Plus, who do you think should be paying attention to this case? Lastly, don't forget to join the conversation. Share your opinions on the drama in the comment section below. Stay tuned for more updates on this case by watching our future videos. Your input is invaluable, so let's keep this discussion going. And that wraps up on Young Thug's case. Judge removed. Fulton County drama explained. I explained it to you, read the documents, looked at the case, brought in the scriptures. Let me bring the scripture back up that what God says about this. You know, this is what God says in Luke chapter 12 verses 2 to 3. It says, "The time is coming when everything that is covered up will be revealed, and all that is secret will be made known to all. Whatever you have said in the dark will be heard in the light, and what you have whispered behind closed doors will be shouted from the housetops for all to hear." I want to thank you for watching. God bless you. God bless your family. And I'll see you guys tomorrow. And I'll keep you up to date with this case. Thanks.